A single federal judge in a courtroom in the Northern District of Texas just wrote an opinion that gun rights organizations have been building toward for years, and understanding how this specific court, this specific judge, and this specific legal strategy came together tells you more about where NFA litigation goes next than the ruling's headline ever could. On August 5, 2026, Judge James Wesley Hendricks ruled that core registration provisions of the National Firearms Act are unconstitutional as applied to suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons. This wasn't a random case that happened to land in front of a sympathetic judge. It was the product of a deliberate, years-long legal strategy, filed in a specific court, built around a specific legislative accident, and structured by experienced Second Amendment litigators to give the court the narrowest possible path to a win. Understanding that strategy matters just as much as understanding the ruling itself, because the same organizations, the same courtroom playbook, and the same careful incremental approach are almost certainly already at work on whatever comes next in this fight. I'm going to walk you through who's actually behind this case, why it landed where it did, and what the courtroom strategy here tells you about where this fight goes next. Before we get into it, if you want to understand not just what a ruling says, but the actual legal chess game behind how it got there, subscribe and turn on notifications right now. Understanding litigation strategy is how you actually predict what happens next in cases like this, rather than just reacting to whatever the latest headline claims, and that predictive power is exactly what separates genuinely following this issue from simply reacting to each new development as a surprise. Let's get into exactly how this case came together. Here is the background you need first. Judge James Wesley Hendricks sits on the U.S. District Court for the Northern District of Texas and was appointed to the bench during President Trump's first term. That matters for understanding the case's trajectory, not because a Trump appointee automatically rules a certain way, but because litigators bringing constitutional challenges to federal gun regulation have increasingly filed strategically in specific federal districts within the Fifth Circuit, a circuit generally considered one of the more receptive appellate courts in the country to Second Amendment and enumerated powers arguments. The Northern District of Texas, and Judge Hendricks's courtroom specifically, has handled a number of significant gun rights and administrative law challenges in recent years, making it a court litigators had real reason to believe would give this specific legal theory a fair, careful hearing. The first segment of this story is who actually brought this case, because it wasn't one lone plaintiff with a grievance. Two cases got consolidated in front of Judge Hendricks, Silencer Shop Foundation versus ATF, and Jensen versus ATF. The plaintiffs included the Second Amendment Foundation, one of the most active and well-resourced gun rights litigation organizations in the country, along with the Firearms Policy Coalition and several other advocacy groups, plus firearms industry members including B&T USA, Palmetto State Armory, and Silencer Co., and notably 15 states joined the litigation as well. This wasn't a scattershot legal effort. It reflected a coordinated, well-funded push involving organizations that have spent years building the legal infrastructure, expert witnesses, historical research, and appellate strategy specifically aimed at chipping away at NFA regulation through the federal courts, waiting for exactly the right legislative opening to make their strongest possible argument. The second segment is the legislative opening these organizations had clearly been waiting for, because none of this litigation happens without a specific, almost accidental piece of legislative history from the year before. In 2025, Congress passed a large piece of legislation called the One Big Beautiful Bill Act, which included a provision reducing the NFA's making and transfer tax on suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons all the way to $0. The original drafters reportedly intended to go further, fully removing these categories from NFA oversight entirely, not just zeroing out the tax. But the Senate parliamentarian, Elizabeth McDonough, ruled in July of 2025 that full deregulation violated the Byrd Rule, the procedural rule governing what can be included in a budget reconciliation bill without needing 60 votes to overcome a filibuster. The deregulation language got stripped out. The tax cut itself, being more clearly budget-related, survived and became law-effective January 1st, 2026. Litigators watching this unfold immediately recognized the opening it created, a tax of $0 still attached to a full registration and approval bureaucracy that had always been constitutionally justified, specifically as necessary machinery for collecting that tax. The third segment is the specific courtroom strategy both sides agreed to, because this detail reveals just how deliberately this case was shaped before Judge Hendricks ever issued his ruling. Both sets of plaintiffs had raised Second Amendment arguments alongside their tax-based enumerated powers argument, claiming these firearms are constitutionally protected arms under Bruin's historical framework. But at a motions hearing held on July 7, 2026, all parties reportedly agreed the court could resolve the entire case without ever reaching the Second Amendment question, if it ruled for the plaintiffs on the narrower tax argument first. This is a sophisticated legal move worth understanding on its own terms. Courts have a long-standing principle of avoiding constitutional questions when a case can be resolved on narrower statutory or structural grounds. And by explicitly building that off-ramp into their own litigation strategy, the plaintiffs' attorneys gave Judge Hendricks a clean, relatively low-risk path to a ruling in their favor, one less likely to get bogged down in the more contested, more heavily litigated territory of exactly how the Bruin historical analog test applies to suppressors and short-barreled rifles specifically. The fourth segment is what Judge Hendricks's actual written opinion did with that strategic setup. He agreed with the plaintiffs that the registration provisions exceed Congress's enumerated powers, reasoning that the entire constitutional basis for the NFA's registration machinery, established by the Supreme Court in the 1937 case Sonzinski v. United States, rested specifically on the theory that Congress can attach administrative requirements to a legitimate taxing scheme. Once the tax dropped to $0, Hendricks found, the constitutional foundation supporting the registration bureaucracy disappeared along with it, since Congress can't use its taxing power to justify a regulatory apparatus that no longer actually taxes anything. He granted summary judgment to the plaintiffs and permanently enjoined ATF and the Department of Justice from enforcing the NFA's core registration provisions against the plaintiffs specifically as to these now untaxed firearms, while explicitly declining to reach the Second Amendment questions both sides had preserved for later. The fifth segment is why this particular legal theory, built on tax law and enumerated powers rather than the Second Amendment directly, represents a genuinely different litigation strategy than most of the gun rights cases you've probably heard about in recent years. Since the Supreme Court's 2022 Bruin decision, nearly every major gun rights case making headlines has been fought using the historical analog framework, arguing a modern gun law lacks a sufficiently similar historical antecedent. This case took a completely different route, one rooted in structural constitutional law, specifically Congress's limited enumerated powers under Article 1, rather than the Second Amendment at all. That distinction matters enormously for predicting how this case fares on appeal, because it means the Fifth Circuit will be evaluating a fundamentally different kind of constitutional argument than the historical analog disputes that have dominated gun rights litigation for the past 4 years, one with its own separate, much older body of Supreme Court precedent governing exactly how far Congress's taxing power actually extends. This dual-track approach, keeping a Second Amendment argument in reserve while leading with a structural enumerated powers theory, also reflects a broader pattern in how sophisticated constitutional litigators have started approaching gun rights cases generally, recognizing that a win on narrower, less politically charged grounds can sometimes be easier to secure and easier to defend on appeal than a win built entirely on the more contested territory of historical analogs, even when the ultimate policy goal, reduced federal firearms regulation, is exactly the same either way. The sixth segment is the immediate procedural reality following Hendricks's ruling, because the courtroom strategy didn't end once the opinion was issued. Hendricks stayed his own injunction for 7 days specifically to give the federal government time to seek emergency relief from the Fifth Circuit Court of Appeals, a stay period that runs out around August 12th or 13th. That built-in delay reflects standard practice for a district court judge issuing a ruling this significant, giving the losing party a genuine opportunity to seek appellate intervention before the ruling actually takes effect, rather than forcing an immediate, chaotic scramble. The Department of Justice retains a clear path to appeal directly to the Fifth Circuit, and given the significance of the enumerated powers theory at stake, an appeal is widely expected rather than something that might simply not happen. Let's step back and name the single thread running through this entire story. This ruling didn't happen by accident, and it didn't happen because one sympathetic judge stumbled onto a clever legal theory in isolation. It happened because well-resourced gun rights litigation organizations recognized a specific legislative opening created by an unusual quirk of the reconciliation process, built a coordinated multi-plaintiff case around that opening, filed it in a court and circuit they had strategic reason to believe would take the argument seriously, and structured their own legal arguments to give the judge the narrowest, most defensible path to a favorable ruling. That is not a criticism of the strategy. It's simply how serious, well-funded constitutional litigation actually works, and understanding that process is what lets you predict, with real confidence, that this fight is far from over, headed next to a Fifth Circuit panel that will be evaluating a genuinely novel legal theory, with implications reaching well beyond suppressors and short-barreled rifles specifically. It's also worth appreciating what this case reveals about the current state of Second Amendment litigation more broadly, 4 years into the post-Bruin legal landscape. The organizations behind this case, the Second Amendment Foundation, and the Firearms Policy Coalition chief among them, have spent years building parallel litigation tracks, some grounded in the historical analog framework Bruin established, others, like this one, grounded in entirely separate constitutional doctrines that happen to intersect with gun regulation. That kind of diversified legal strategy, pursuing multiple independent paths toward the same broad policy goal rather than betting everything on one argument, reflects a level of institutional sophistication that's worth understanding on its own terms, separate from whatever you personally think about the underlying policy questions. It also means that even if this specific tax-based ruling gets reversed on appeal, the broader legal effort these organizations are pursuing doesn't simply end because the Second Amendment arguments preserved in this exact case, along with entirely separate cases being litigated elsewhere, remain very much alive regardless of how this particular appeal resolves. If there's one thing worth taking from this breakdown, it's that a major court ruling rarely emerges from nowhere. It's the product of deliberate strategy, built over years, waiting for exactly the right opening, and understanding that strategy tells you far more about what happens next than the ruling's headline ever will. If this helped you understand the actual story behind this ruling, share it with someone who's only seen the headline version, subscribe so you catch the Fifth Circuit's next move the moment it happens, and I will see you in the next one.